All right, so we're going to get started with back up with the panel, and we have a slight change to the schedule. Instead of breaking for lunch at 12:30, I think we're going to just do another 15-minute break and then come back and do next steps. So to jump right back into it, on the legal and policy side, the FCC has recently reclassified broadband as a telecommunications service in its open internet order. So what are the bounds of the state's jurisdiction over the service? What should they be, and how should the state react to that important reclassification of broadband as a telecom service? And I think we'll start with Michael.
Well, great, thank you. So the question is phrased, how should the PSC treat broadband now that it's being reclassified? I think my one-word answer would be carefully, because it's as so many things are in this space, it's a lot of gray area and uncertain at this point. So, but I'll just go through kind of some of the notes I took on what the order says and how it might be construed. So the first thing to keep in mind is that just because it's being reclassified as a telecom service doesn't give anyone sort of a blank check to regulate the service. As a telecom service, the FCC was clear in its order that it tailored its approach to broadband as a common carrier service. I think it used the term 21st century common carrier regulation, which to me is a little oxymoronic because common carriage goes back to the Middle Ages. But the FCC tailored its approach, and so, as I mentioned before, the states are bound by that forbearance regime. Second, the order is being challenged in court. I think everyone knows that. The DC Circuit should be ruling pretty soon, I imagine. Oral argument was in December. A decision should probably come out in the next month or so. That'll probably be appealed soon thereafter, either to the full DC Circuit or to the Supreme Court. That'll play out over the next year. So there's uncertainty there. There's debate certainly over whether the FCC had legal authority to do what it did in the order, reclassifying and doing everything else it did in the order. But I think there's pretty wide agreement amongst everyone who's followed the case that whatever the DC Circuit rules will be very complex. And it could be the case where it upholds parts of the order, strikes down parts of the order, remands certain parts back for further proceeding. So it'll be messy, to put it lightly. But just looking at the order itself, it does address the issue of state authority in several instances. And it's clear, for the most part, that state authority is limited, except when it says that it's not. So just to go through a couple of examples about the limits of state authority in the order. So, and there's a dedicated section in the order on this issue. So one of the first limits is that the FCC affirms, it makes clear that broadband is a jurisdictionally interstate. So that automatically puts it beyond the reach of public service commissions. Second, as I mentioned before, states are bound by the forbearance regime that the FCC put in place. So the FCC forbore from dozens of statutory provisions and hundreds of rules, and selected about a dozen or so specific provisions to apply. The states are bound by that regime, so the states can engage in things like rate regulation, which is beyond the scope of the FCC's regime. Some of the U.S.F. Limitations that I mentioned earlier that they might roll back in the lifeline context, as we discussed before. The FCC also makes clear and says pretty explicitly that it won't hesitate to preempt states if they go beyond their regime or they try to implement policies or obligations that are inconsistent with the order or with federal policy generally, and that's pretty basic conflict preemption that the FCC has invoked many times in the past, much to the chagrin of states. But There's pretty long precedent there. But interestingly, in several parts of the other parts of the order, the FCC acknowledges that, of course, the states have a role with respect to broadband. So it kind of carves out this very gray area for states. One quote is that finding that the service is jurisdictionally interstate does not by itself preclude all possible state requirements regarding the service. And that's in a footnote 1276, if everyone's following at home. And then the example cited in that footnote was data collection. There's an order from a couple of years ago around data collection. And then in a paragraph, 100 paragraphs later, there's another mention of states where the Commission notes that as part of its forbearance regime, it does not forbear with respect to provisions of the Act insofar as they merely reserve state authority. So there are other parts of the Act that reserve authority to states, and those things include ETC designation, which might change, possibly in the lifeline context. Section 253 around rights of way management, Section 332 when it comes to sort of wireless carve-out for states, and then also Section 706, which I think we'll talk about in a little bit. But that's kind of what the order says, and that doesn't really provide all that much clarity. One could interpret it as a blanket prohibition on what states can do unless and until the FCC tells them that they can do something, like in the case of USF reform. Or one can interpret it as the FCC acknowledging that there are gray areas and that the states could probe those outer limits of its jurisdictional, new jurisdiction over the service in light of the Open Internet Order, but that the FCC reserves the right to kind of manage how the states do that with the looming threat of preemption. And there's also legal precedent on the books showing or underscoring that the FCC has pretty broad authority to manage how states implement or interpret and implement the Act, especially under Title II. And that goes back to the aftermath of the 96 Act when there was considerable uncertainty about the interplay of state commissions and the FCC when it came to things like unbundling and interpreting the complex array of obligations that were included in the Act. You know, the seminal case, the Iowa Utilities case from 1999, underscored that the FCC, even when there are clear delegations to states, can still manage their interpretations and applications of provisions of the Act that have sort of federal consequences. So, all that said, I think being careful in interpreting and applying this seemingly new grant of authority might be the wisest course of action, because it seemed like the FCC opened the door to more regulation of broadband under Title II, but there's only really room for the FCC to go through it at this point. So, but the legal challenge might cast some doubt on that. Subsequent orders might loosen up some of the requirements. Subsequent FCCs could unforbear from certain provisions. So I think time will tell, but I think right now there is still considerable uncertainty about what would happen if a state kind of tried to probe what this means in practice.
I like the term carving out a gray area. I think that's that's sort of a good take on how unclear some of the provisions of this order might be. Maureen, I'd like to turn to you, since the cable providers are currently the state's dominant broadband providers. What's the interpretation from that perspective of the Open Internet Order and what it might mean for state regulation?
Well, I would second everything that Michael said about the federal limitations that will still be in place with respect to these services. But I would add one more limitation, and that is state law. The public service law, from my perspective, does not give the Commission the power to regulate broadband. It's pretty clear from case law that, the simple fact that the FCC allows a state to regulate something does not give it an independent basis to regulate that thing. So I think in addition to seeing how this plays out in the litigation and then subsequently how it's implemented by the FCC, we need to look at the state law and how that applies. The question is written interestingly because it's what are the limits of the state's jurisdiction, and what I just discussed relates to the Public Service Commission, not necessarily the entire state. And I think Joe mentioned a couple of things that the state could do in terms of tax incentives. We've seen what the broadband office has been able to do. There are plenty of things that the state can do, which the Public Service Commission obviously is very integral in assisting with. I know they work very closely with the broadband office on its programs. So I do think there is a role for the state in these issues, but I don't think that this order in and of itself grants the Public Service Commission the ability to regulate broadband.
So I'm a half glass full kind of person, so when I hear gray areas, that's okay. So I'm curious to focus a little bit less on the limitations in the order, because I think those are pretty clear and I think we all accept them. So what areas are unclear, and I mean that in the best possible way, where the states and the feds have alignments on policy on things like universal access and reliability, especially when it comes to emergency response, where there's an alignment of federal policy and state policy in a gray area, what does that mean? Yep, Joe?
Actually, I was raising my hand because and if you'll indulge me for just a minute, I wanted to expand on what Maureen said about the role of state law here. Maureen is quite right that the question of whether the FCC is preemptive jurisdiction or reserved state jurisdiction is secondary to the question of whether the New York State Legislature has conferred that jurisdiction on the Commission. And aside from the issue that Maureen mentioned, that it's not that there's no explicit grant of subject matter jurisdiction over broadband service in the public service law, there's another important aspect of the internet, of the open internet order, which is that it very explicitly classifies broadband internet access as an interstate service. And that has implications for state law because Section 90, subsection 2 of the Public Service Law limits the Public Service Commission's jurisdiction over telephone services to communications between one point and another within the state of New York, which is an old-fashioned way of saying intrastate service. So I think the implications of the FCC's classification of broadband internet access as an interstate service go well beyond the various gray areas, preempted areas, and non-preempted areas that are delineated in the order. As for looking at the glass half full and what the state can do, I agree with Maureen on this point too, that the most promising approaches are approaches that are more directed towards the state, more calls for action for the state legislature than for the commission. And they include, as previously discussed, state taxation, adoption programs, the very critical area of rights of way. And I'm sorry we don't have time here to give that give that issue what it deserves, but rights of way are a very critical issue. There may also be areas of cable television regulation whereby relaxing its current regulatory framework, and to some extent this would have to come from the legislature, although in part it grows out of commission regulations, the commission could remove disincentives to deploying cable television networks and therefore to deploying video-capable broadband networks.
I would say that there's a whole nother aspect of this conversation that, where I too see it as a glass half full, not a carving out a gray area, though I do like that turn of phrase. Might be good now to discuss 706. Right, and the classification of broadband as a telecommunications service doesn't change the fact that 706A is still the law of the land. And 706A unambiguously grants the state the regulatory jurisdiction to work to deploy advanced telecommunications in a reasonably timely manner and to remove barriers to entry, which I'm sure would satisfy some of the concerns that Joe's raising, while also addressing important public interest and universal service concerns. So I don't see the open internet order as overly constraining the state from doing the state commission from doing its job.
Well, I think, sorry, just, I do think 706 is the biggest gray area that is kind of somewhat implicated in the order by. I see Commissioner Sayer getting ready to ask a question, so. Oh, okay, all right. Okay. Well, no, I think Section 706 is a huge gray area, but even there, it's still, arguably, it's not a blank check to a state. There are still limitations. I think we'll probably get to that later, but even 706 is limited to the narrow issue of deployment and infrastructure investment. So, trying to build a regulatory regime around outages or emergency response or consumer complaints to 706, I think would require some creative legal arguments to tie it to the narrow mandate of deployment and an infrastructure investment under 706.
I would disagree with your analysis because I think the Verizon court found quite clearly that the virtuous circle is a real thing and that lots of things go into investment, go into adoption, go into the deployment, and that the virtuous circle that drives investment and the sort of the broader ecosystem of communications. The Verizon court found that the FCC that providers have an ability and an incentive to interrupt that virtuous circle, and that there is an important role for regulation to maintain that virtuous circle. It only found that Section 706 was not sufficient to sustain common carrier regulation. And then that's why we went through everything we did to get to the Open Internet Order of 2015. So I would respectfully disagree. I don't think actually, I think 706 is about more than just deployment in lowercase. It's about the entire virtuous circle of the ecosystem of investment and innovation and adoption.
Right, that the court did agree with and agree with the FCC's use of virtuous cycle and that analysis, but one could argue that it's very expansive, but within that context, it was the virtuous circle.
They use both interchangeably in the interim.
So
we will too.
Cycle, I guess, is a good one. So the virtuous cycle in the order and in the 2010 order, the Verizon case, and in the 2015 order, looked at the narrow kind of the relationships between the service providers and the edge companies, and the FCC interpreted the cycle as moving in one direction from the carriers to the edge, and the carriers having the incentive and the ability to harm edge companies, so that impacted the virtuous cycle. But within the specific context of things outside of that narrow context, I think it would be plowing new ground to make a legal argument that, again, like a new regulatory regime on consumer complaints or something else that's being contemplated would require new arguments. I mean, even to fit within that virtuous cycle framework, the FCC didn't contemplate that in their original interpretation and application, and when they did so in the 2015 order, they grounded it in Title II and not 706. So,
But 706 is still the law of the land. And
right.
so I guess, actually, perhaps we should defer to Commissioner Sayers' question.
Does the panel, at the risk of hijacking the next question, does the panel have a position under the public service law, not 706, but the public service law itself, as to whether we could mandate pole attachment capabilities on behalf of pure play broadband providers that don't have a CPCN and are not cable TV providers?
Is it,
Anyone?
I honestly, I haven't thought about it. I think that's a really interesting
I
question.
must admit I'm in the same position.
Let me, oh, sorry, go ahead.
Let's marinate on that.
Let me then try to get at some of the contours around 706. So everyone's aware of the Commission's Charter Time Warner order and the requirements in that order. Outside of that context, outside of the merger context, so to speak, what are the concrete steps that you folks envision the Commission might be able to take or can take to fulfill its role to mandate or encourage the deployment of broadband networks? I'm just going to throw some examples out there to get the conversation going. Is it about coming up with a I don't want to say franchising because that's not the right word, but a sort of clearinghouse to be able to get on poles as a broadband provider? Or is it about jumping into the broadband lifeline space? What can and should the Commission do to fulfill its role in this regard? And I'll start with Maureen. We'll work our way down.
I hate when I sit at the end of the table. I would repeat what I said earlier in terms of, and what other people have said earlier in terms of the remaining federal preemption issues and state law issues. But I would also like to bring your attention back to the second half of that paragraph. Not just this state commission, but state commissions generally and others tend to focus on this mandate to encourage deployment on a reasonable and timely basis. But the second half of that paragraph, I think Michael makes the argument that it's not exclusive, but I think it does give you a flavor for the kind of things that if states are going to dip their toes into this, that they should be focusing on. Public interest, convenience and necessity, price cap regulation, regulatory forbearance, measures that promote competition in the local telecommunications market, or other regulatory methods that remove barriers to infrastructure investment. Now, we can have an argument about whether that last portion limits all of the others, but whether you accept that argument or not, I think the intention of this paragraph is to provide a regulatory environment that encourages investment and does not add the kind of regulatory burdens that have typically been applied to monopoly local exchange companies.
I agree with that. I think it's incredibly significant that Congress specifically listed regulatory forbearance as a Section 706 strategy. The second phrase that Maureen quoted, removing barriers to infrastructure investment, appears in both A and B and is equally important and to a large extent goes to the right-of-way issues that I raised previously.
so I think, yes, I'm sorry, a follow-up question. Removing barriers to infrastructure investment, whether it is the sole part of 706 or a piece of 706, I think we all agree that that's a good place to be. I hear some commentary that regulatory forbearance gets us there, but yesterday's panel, we talked a lot about the need for more build-out. At least there's a significant to New York State, there's a significant enough lack of build-out in our state that we have a concern. So where can the state, in support of removing these barriers to infrastructure investment, what can we do to generate the investment in the areas where there hasn't been any to date?
Well, I think the governor's program is an example of exactly what the state should be doing.
Okay, anything else?
And I think the list that Commissioner Sayre put out yesterday, although I may not agree with every subpart of it, and Joe's allusion to right-of-way access, pole attachment issues. The parts of the state that we're still talking about kind of fall into two buckets. One are inner city areas that are, or not even inner city, but areas of the city where building access is an issue. Every commission session now, you see 20 or 30, orders of entry from Verizon or others, where they're having difficulties getting into buildings, and the commission has been, Joe can opine on this on his end, but the commission seems to have been very helpful in terms of getting into these buildings. And then, of course, on the rural side, it's getting to the facilities, whether they're business facilities or residential facilities. And, as we mentioned yesterday, sometimes that requires connecting parts of your network that are separated by either other franchises or by no franchises. It deals with, kind of the hijacking that certain entities will do when you try to get onto their poles and have them, have them ask you to replace all their poles in order to get on their poles, or putting undue burdens in terms of costs onto pole attachers, the make-ready issues. There is a lot of room for public involvement, and I think you mentioned, Graham, some kind of a clearinghouse assistance for pole attachments is, would be a terrific idea. But it's also other state agencies. There are, we talked yesterday about the parks and how tough it is to get through the parks. Again, in the rural areas, those are the kinds of issues you're dealing with, is stringing wire across long terrain.
So we hear that, and we heard that a lot yesterday. I think it's really interesting about, there's a lot of herding cats and different stakeholders, but we've heard also that there's not an economic incentive to go to those remote areas. So if the state, PSC, and its various stakeholders were to assist in reducing those barriers on pole attachments and zoning, and I think Jeff talked a lot about this yesterday too, will you come?
Well, you're fundamentally reducing the cost of entry when you get rid of those barriers, because every one of those things is time and money, and increases the cost of going to those areas. And what you've seen over time, and again, I can only speak from the cable perspective, what you've seen over time is, as you've added more services that are available to an individual customer, so you're not just selling one voice service, you're selling voice and cable and broadband. The areas of the state that are attractive to serve are ever increasing, and the population or the density or the distance that you have to go changes over time as the economics of the products change over time. So, are you saying if you took care of all these things today, would we solve the problem tomorrow? No, but over time, I think to the extent that you can reduce the cost of entry, you will increase the possibility these areas will be served. The companies want more customers. It's a very simple calculus.
So can I follow up on that? Because it seems to me, and this is that what we're hearing is that the state can make efforts to obviously reduce the cost of acquisition, but that we can't really control the pace of acquisition, because that's where the providers are saying we're without jurisdiction. And to follow up on Karen's issue, and this is legislation is never immutable. What we don't have authority about today, we could get authority about on a state basis. So I don't see that as a barrier if it's the right thing to do. From a policy perspective, the struggle, isn't it, is that as we start to move to broadband as sort of the base technology for services we've traditionally regulated, like voice communications, and increasingly see the need for other forms of communication, isn't the challenge and policy concern that we have a gap in regulatory authority about is that the state has a very peculiar interest to make sure that there isn't people who are unserved because the pace of competition may not be sufficient, or because they can't afford the service, and then what do we do then? I mean, are you simply saying too bad? That's the way it is?
No, not at all. And I think the point is important, that the state itself has tools, and the state itself is using those tools. And if there are indeed customers that are really not marketable, and you also have to ask the question whether the customer wants the service. I mean, there are, and we've talked about this many times, cabins up in the Adirondacks where, people move there because they don't want service. But, putting those aside, to the extent that there are communities that are just fundamentally uneconomic because they're so far off the beaten path or so far from the networks that are out there, that it will never be economical for a particular company to serve them. That's when the state steps in and provides an incentive, and if there's a third party or if there's a local ILEC or what have you that's willing to step in and take that role, then that's an appropriate role.
I'd like to add something. I would sort of agree in part and sort of concur in part and dissent in part with Maureen. I think there are.
You should,
Yeah.
the FCC.
That's right. I think there are important things that the state can do to promote policies like One Touch Make Ready or Dig Once that can assist with facilitate deployment. We need to be really careful, though, to resist the temptation. Let's keep it surgical, I think was the term this morning. It's really easy to throw away a lot of important, long-standing, hard-won, and meaningful consumer protection in the effort to just sort of quote-unquote clear out the regulatory underbrush and do away with important protections. In other states, including my own home, North Carolina, we've seen things like franchising law get wiped away. We've seen things like carrier of last resort get wiped away. And the promise is always, if you deconstruct it, if you deregulate, we will invest. And I think if you look on a state-by-state level, there's not very much, there's barely any correlation between state X deregulated and 1,000 flowers bloomed. If you look, it's a patchwork based on broader macroeconomic concerns. Does it make sense to invest here? Yeah, more or less, it does. Does it make sense to invest there? No, it doesn't. Does that have anything to do with whether we have local franchising law? Does that have anything to do with whether we have a public service commission with teeth? Does that have anything to do with whether, with access to public lands and parks? On the whole, no. And so I think we need to be awfully careful about doing away with a lot of very good, meaningful and common sense consumer protection in the name of chasing capital investment. As Maureen says, you're facilitating it and making it a little bit, the cost to acquire that household or that consumer marginally less. But there's a difference between that marginal here, right? At what cost? And if that consumer is still not economically advantageous to serve, they're not going to be served, even if the cost is marginally less. So I would urge caution when it comes to doing away with important consumer protections. As I said earlier, the state here was wise enough to leave standing its carrier of last resort, and that's why you were able to exert your jurisdiction, and you were able to hold hearings in Fire Island a few years back and have people come out and say, well, your voice link is not sufficient for my small business, it's not sufficient for my life alert, it's not sufficient for my home phone. And so think about where you might be if the state looked up and realized, oh, we took all of these measures to facilitate capital investment, just like, I think Pennsylvania, for instance, is deregulated in large part. I don't think the broadband picture there is much better or worse. It's a patchwork just like it is across New York State. And I'll add that the only other point where I'm going to disagree with Maureen is you said there's sort of two buckets. I'm not really sure there's two buckets between the inner city and then sort of the outlying areas.
In terms of the problem I was talking
Well, but I think if you look at a place like Syracuse, we don't have, getting FiOS in Syracuse has been a fight. And I don't think you can, I don't think that really fits in your nexus.
You're right. You're
Yeah.
right. It was an oversimplification. And one other clarification, Tom. We're not suggesting wiping out regulation. The theme yesterday, and I think the theme today, is to say that a lot of private capital was put into the state, I will say by the cable companies, others as well, based on a certain regulatory regime, which has worked pretty darn well. And what we're cautioning against is to be very careful to change it, and frankly, one way or the other.
Can I ask a question? Because yesterday and elsewhere, a proposal has been made for the commission to change the definition of basic service requirements to include, as I understand it, I think the proposal is to include broadband as a part of our basic service requirement. So is that a proposal? And so I guess my question is, what would that proposal look like? And how would it fit in this carved-out gray area?
Well, I think this is one case where reclassification actually makes it quite clear. You have the protection that traditionally you have the jurisdiction that was traditionally afforded to you for basic telephone service. Now you have for basic broadband.
Well, that's not quite the case. I mean, as I mentioned before, the FCC is pretty clear in the fact that it's not. It's kind of like it's Title II light, or what they call common carriage light. It's not the full bore. So the FCC said that broadband is a telecom service, but only in this narrow statutory construct that it kind of carved out of Title II. And a lot of those authorities were kind of cited to uphold its open internet rules. That's pretty much the universe of that legal regime exists within the open internet context. So for a state to leverage that into layering on legacy POTS regulation onto broadband, I don't know if that would be legally viable.
Yeah.
I think that might be a little bit beyond the scope of the open internet order, which is, again, the context within which the common carrier, the new common carrier regime exists.
Peter, we've talked quite a bit about, broadband availability and what should be done about it, and I don't want to repeat all of that. I do think, though, that there's an important point here, which is that classifying broadband as a basic service is a very blunt tool, and I don't know that it is even meaningful. I mean, other than as an aspiration. What would that mean? Would that mean that a regulated provider couldn't offer service unless it also offered broadband? And what kind of broadband are you going to force it to offer? I think that's exactly the direction the state doesn't want to go on, because if you want a robust, multi-carrier, facilities-based competitive environment, you want to leave enough room for carriers in response to their customers' demands to offer a lot of different service models. And, simply classifying broadband as a basic service is not really going to enable you to avoid the hard questions of what should we do to encourage broadband. And in some cases, it's going to lead you, as I said, in exactly the wrong direction by encouraging overly blunt approaches that are going to inhibit facilities-based competition rather than foster it.
So, Joe, you mentioned facilities-based competition. We heard a lot yesterday from folks who don't think that there's competition in the broadband market. So I guess I want to tie back into 706 by asking, what should the role of the commission be, or what can the role of the commission be in encouraging the overbuild that folks seem to want to ensure that competition exists? And I'll start with you, Joe, and then I think I'll turn it over to Todd, because I think he's got something he wants to say on that.
I'm not sure I have anything startling to say that I haven't said before. I think basically what the commission can do is in the words of 706, think about regulatory forbearance and removing barriers to infrastructure investment. But I think as far as affirmative measures that will encourage broadband deployment, they would appropriately be addressed to the state as a whole and to other agencies of the state. And we've surveyed some of them: tax policy, right-of-way management, and so forth and so forth. I mean, to the extent the issue is economic unviability of the service, I don't think command and control regulation is going to resolve that issue. What will resolve that issue is the targeted, smartly targeted expenditure of public money, which should be raised, because this is a broad social problem, should be raised, should be funded through revenues obtained from the broadest possible base in the state, and not placed on the back of a small number of regulated companies.
At the risk of being the skunk at the party, I think the commission may have recently made some decisions that are at cross purposes with its goal of promoting facilities-based competition. To wit, blessing the Charter-Time Warner Cable merger was a mistake. The acquisition, the heavily leveraged, debt-heavy acquisition of Time Warner Cable by Charter, which has been provisionally approved on the state level, it only makes overbuilding less likely. The larger the incumbent, the harder it is to be a new entrant. The more benefits of scale that you accrue to the incumbent, the more challenging you make it for a new market entrant. And so, to the extent that there are that there are ILECs that are thinking about investing, that there are competitors that are thinking about entering the market, their whole calculation about will it be smart for me to invest in this geography is driven in large measure by what's the other guy's business model? Oh, he's able to purchase content at a much lower rate than I am. His programming costs are so much lower than mine per unit. I'm never going to be able to compete with his programming costs because I'm a new market entrant and I don't have the benefits of scale. So actually, the larger you make the incumbent, the harder you make it for the next guy to come to enter the market. And to use a crude analogy, the bigger the bully on the block is, the harder it is to, the less likely you are to come around. And so I would, if there's anything the commission could do to encourage overbuilding, one, the era of cartel-like turf between cable companies should be over, right? The supposition that cable will never compete on a household-by-household basis should be cast to the dustbin of history, like the relic that it is. Two, let's put the brakes on these mergers that are not in the public interest, and the commission has another one pending right before it as we speak. Let's think long and hard before we bless any further cable mergers that make it that much more difficult for new market entrants to enter, because any antitrust decision, any merger and acquisition decision shouldn't be predicated just on an analysis of the market situation today, but should be forward-looking and thinking about what competition are we foreclosing in the future. And I think I'll leave it at that.
Could I? Sure. So to tie all the questions together, I think it's the issue we're discussing is two problems that are looking to be solved. One is bringing broadband to unserved areas, and two, addressing what some would describe as a lack of competition in other areas. And so it's how do you solve either of those problems? And so on the unserved areas issue, from the Public Service Commission's perspective, the traditional route has been universal service funding, but in the state, at least according to the assessment, it's a tiny amount of money. The governor's program has stepped in with something like 40 times the amount of funding available in the State Universal Service Fund as a way to attract what they hope to be one-to-one matching, topping it up to $1 billion. And that's an enormous commitment of money to address unserved areas in the state, which are relatively small in number, purely unserved areas, at least according to the state's definition. So that piece, that piece is working. It's on track. The governor's programs up until this point have allocated tens of millions of dollars, has succeeded in attracting private partners to build out to these unserved areas. Certainly, one would think that offering even more money under this New York program will help to bring more broadband to unserved areas. And it's worth noting that, and jump ahead to part of another question about whether the state can mandate certain types of network architecture or things. Unilaterally, no, but within these grant programs, the state is free to attach or to craft them in such ways that they affect certain outcomes. So the New York program Phase 1 has been structured in a way that has certain requirements included in it that will, in theory, result in certain outcomes in terms of speeds and things like that. It doesn't require so much a specific network architecture, but by defining speeds at a certain level, you kind of narrow the playing field a little bit to certain types of providers. So if you have a target of 100 megabits per second, say, or 50 or 25, then that narrows the field and kind of cuts away fixed wireless, for example. And so that raises the policy question of whether getting some broadband to an area is good now, or if we want to narrow the field and have certain types of providers. So would fixed wireless now make sense, and then making the business case and showing that there's demand in certain areas to attract further investment, or if through this program want to get to a certain type of network architecture. It seems like in Phase 1, it's more towards the latter half. On the issue of perceived lack of competition, what can the PSC do? I think it goes back to what I think Maureen discussed before and we heard about a lot yesterday when it comes to barriers to deployment. That's under 706. What does the PSC have specific authority to do to remove these barriers, and things like the not very sexy things around pole attachments and things like that are, it sounds like, at least from the providers, that that's something that would potentially make them invest more. But the Public Service Commission, for example, can't mandate unbundling of networks. That's something that the FCC could theoretically do if its reclassification survives legal challenge and they unforbear from those provisions, but the state can't do that. But again, if in tailoring a grant program or something that would require or heavily sort of tip in the favor of subsidizing build in certain areas that have to be open access, I mean, that's what the federal government did in the stimulus program when they funded open access middle mile networks. But that's more of a policy choice of whether the state wants to subsidize open access networks or subsidize overbuild when there are these clear needs in these unserved areas.
And I think there is a connection between the unserved and the lack of competition, and it does come back to the percentage of people where there is no economic value to build there or to maintain and upgrade and innovate those networks. And I think the upgrade and innovate is important. You might get some money to build out there, and you might get grant dollars to build the systems, but you also need the incentive to continue to innovate and upgrade them. So that's the pocket of people where we're really challenged, is getting the networks out there, providing some public dollars or incentive to do it, but then to continue that in this space, which we keep seeing is growing and expanding at such a fast rate, ensuring the sustainability, that the innovation and the upgrades will continue both on the public side and on the private side.
It's happening, Karen. Especially, again, from the cable perspective, these networks, there isn't a voice network and a broadband network and a cable network. It's one network. And each of those subparts are competing against different entities. So whether it's a new innovation on the video side that requires them to upgrade their system for that part, or one of the other two parts, they're constantly reinvesting in the network. And it's one of the points that they've made is the fact that it's not enough that there was this, and it wasn't one shot. It was an ongoing infusion of billions of dollars. Factually speaking, the companies are continuing to invest in their networks. They're continuing to push out fiber farther and farther into the tentacles of their networks. They're continuing to invest in new electronics to make these networks smarter, and the connections to the house smarter. It is happening. The argument yesterday that companies don't have an incentive to invest in their networks is just completely false.
I would agree that companies have an incentive to invest in their networks as they stand, but they don't have an incentive to invest in the areas they don't yet serve. And the question here is the underserved areas. And I think that if we want to talk about facilities-based competition, again, I'm going to sound like a broken record here, but if a company like Charter has tens of billions of dollars to expend on entering the New York market, they should come and fight Time Warner Cable and Verizon on a household-by-household basis and compete with facilities-based competition. That instead of blessing merger after merger, we should be looking at ways to actually bring competitors into the market.
So maybe that implicates things like franchise reform. I mean, as we heard yesterday, the Google Fiber model has kind of highlighted how antiquated in a lot of ways the franchising model is, with build-out requirements and things like that. I mean, maybe that's something to look at.
So what would a new franchising model look like that, in your opinion at least, would encourage this facilities-based competition?
Eliminating build-out requirements, eliminating the level playing field rule.
I didn't mean to interrupt you earlier,
no.
but I think we can have a conversation about franchising, and I think there's always been an understanding that non-dominant carriers and new market entrants might be afforded a phase-in, that they may not have to serve all households on day one that they light their network, that they might have a time stagger that they could progress through and maybe serve some of the more valuable customers, and then as they get to farther out. But I wouldn't want to throw out all franchising at once. I would say, though, just to push back on your point, though, the idea that Google doesn't invest Google Fiber in states that still have franchising is belied by the fact that just yesterday they announced they're delivering Google Fiber to their hometown in San Francisco. And
Over using existing fiber. They're not building new fiber.
well, as with Huntsville, they're exploring a variety of models that make sense in a variety of different geographies based on anything from local market conditions to the local policy framework. And
Why should that not be permitted for carriers that don't happen to be named Google?
I have never asserted that Google deserves any kind of special status because they are Google, and I wouldn't.
Okay.
At the very least, it raises interesting questions about the need maybe for modernizing franchise processes in states, as well as, and to raise it up in even to a larger level, revisiting, because franchising process is, it's been around for a long time, and that specific model has been around for a long time. Maybe it's time to revisit. Maybe not, I don't know. But I'm not advocating either way, but it's interesting to see that towns and cities have fallen over themselves to cater to Google in a lot of ways. I think someone mentioned yesterday raised the notion of redlining and around their demand aggregation strategy, which would not play well at all in New York if a carrier tried to do that. But towns are willing to let Google do that, and I mean, it's still very popular, and cities are still trying to get them in. So I mean, maybe looking at that model could potentially, I don't know, maybe raise some interesting things that could be considered here. And then also, again, to the bigger issue of looking back at these legacy and historic models that might need to be revisited because they were crafted in completely different contexts. The franchise model came out of a completely different context than what we're seeing today with Google, kind of highlighting that very stark contrast. Maybe there are other regulatory regimes, statutory regimes that need to be looked at that might be holding back investment, pole attachments, things like that. So I'll stop there.
A fruitful example might be Los Angeles's RFP for fiber investment. Not the first RFP that went more or less, it didn't really work out, but they went back to the drawing board, recrafted it, and addressed several of these questions in a way that I think actually strikes a meaningful and equitable balance that really avoided a lot of the redlining concerns. But I know we're not here to debate Los Angeles, but it might be worth review.
So, Joe, you mentioned a few things in the current franchising process that you could see removing, eliminating. There is, however, some proof out there that going to a statewide franchise and removing some of these barriers don't actually do that much. There's a study out of Minnesota, I think it is, that essentially indicates that the investment that folks thought was going to come with statewide franchising didn't appear in a meaningful way. So from, I guess, your perspective, Verizon and Maureen from the cable industry, was it something about those statewide franchising laws themselves that didn't work, or is it more about a surgical approach to reforming franchising rather than a blunt instrument?
Well, I'm not familiar with statewide franchise laws anywhere else than in New York. I've looked at a number of them that have been proposed to this state's legislature. And as soon as the concept was introduced in the legislature, immediately everyone had a list of, I want this, I want that. So they were larded about with dozens of different mandates and requirements, statewide build-out requirements within X years, benefits to municipalities, et cetera, et cetera, et cetera, none of which created a very attractive environment for investment. I think to the extent that, you've heard Bob Puckett and others argue for statewide franchising, that's not the construct they have in mind. Whether, that kind of construct could ever, a more desirable statewide franchise construct could ever get through the state legislature, I don't know. I was talking about more limited measures. I think the existing regulatory scheme, which in the state, which is partly statutory, partly regulatory, does create disincentives to build out. I know in our case, we would have been happy to build out in certain communities on a limited basis, and not a red line basis, not disadvantaging anyone based on income or socioeconomic criteria or ethnicity, but just building out in more limited areas than a municipality, which is an arbitrary geographic entity anyway. The commission has taken an approach that's varied in stringency from time to time, but the bottom line is that has not been a feasible model under the current regulatory framework.
Well, and the reason is the commission's level playing field rules, which, we are supportive of. The things that I think were being referred to a minute ago in terms of the legislature are kind of exactly what I was responding to Commissioner Sarah about yesterday, when I said that statewide franchising is just politically, it's a very difficult thing to do. I mean, aside from the regular legislative process, you've got a lot of municipalities that, simply don't want to have their positions usurped. And, I don't like to say don't do something because it's difficult, but, when it comes to the legislature, I do worry that, where you start out with and what you want to begin with may not be what you end up with.
So I think we've had a lot of conversation about the open internet order and 706, and some conversation about how to balance those two things, but I thought I'd crystallize that question. What are some examples of how the state or the PSC can balance the instructions and the gray areas in the internet order and the instructions and limitations or lack thereof in Section 706? And when we start, we'll start at this end this time, Maureen, and we'll work our way down to you.
I think Michael and I maybe disagree on which part is gray, which area is gray, but
There's a lot of gray.
there's a lot of gray. Or to mix metaphors, maybe I think the glass is half fuller than.
It's okay. I like
yeah.
gray too, so
Yeah.
it's okay.
I will say this. I think that we should see this as an opportunity, not a challenge. Again, to reiterate, the 96 Act and going all the way back to the 34 Act envisioned interlocking and at times overlapping jurisdictions between state and feds. That's a good thing. That means consumers have more eyes on the, more eyes on the problem. That they have people that are closer to local concerns and can address local issues more responsively, that this is not that, you know, again, to your point, state variability and regulation doesn't have a whole lot of impact on capital investment, but it does have a lot of impact on consumer protection. So I think that I would encourage the commission to be bold and look for, you know, as muscular a representation for consumers as it can.
I think there's an opportunity, given the uncertainty, gray areas, what have you, and the potential, likely potential for litigation and things being gummed up in the courts, which for law students is a great thing. And I always try to convince students that this is a fun area of law to work in because there's so much going on. But
Do they buy that?
no, they don't. They inevitably gravitate towards the edge issues like IP and things like that. Anyway, but I think there's an opportunity, given all that. I think most people will agree there's some uncertainty and some areas of gray and the potential for litigation. But there's an opportunity to kind of look beyond the specific wording of 706, but still keeping with its spirit. And so thinking more broadly about the issues of broadband deployment and not being fixated on what can the commission do or can it regulate a specific outcome, but thinking broadly. And when you look at the sort of cornucopia of things that the state is doing around broadband deployment, which is the specific mandate in 706, the state's doing some really interesting things. And so arguably, that would satisfy the requirement of broadband being deployed reasonably and timely in the state. The sort of totality of circumstances in the state would argue in favor of the circumstances meeting the statutory requirement. So thinking broadly and positioning the commission as the kind of hub for working across agencies or government to not so much tell what the other folks should be doing, because I don't think that would work all that well, but to see if there are gaps in what's being done in furtherance of broadband deployment. So on the issue of bringing broadband to unserved areas, the broadband office is doing some really great and interesting things. But perhaps there might be opportunities in the next phase of grants for the commission to opine on requirements that should be potentially included. They can't direct the broadband office to do that, I don't think, but they could probably offer their opinion on what should be in there and things like that. But and then focusing specifically on what there is clear authority to do generally, and it seems like there's some consensus around the notions of things like pole attachments again, removing those barriers to investment that it is a clear grant of authority in 706, and then the issue. So thinking broadly, I think, is generally a good thing, and I think there is potentially a huge opportunity for the commission to position itself as some sort of cross-government facilitator or of some sort to be it is the expert agency on these issues, so to offer its guidance and advice on some of these issues. And then removing barriers to deployment. And the other point I was going to make is with respect to reconciling 706 with the open internet order. I, again, don't think that conveys all that much new authority to states from the perspective of layering on traditional regulatory requirements that used to attach to telecom services. There are a huge number of limitations outlined in the order that would, I think, prevent those sorts of actions.
I'm just going to briefly touch on some of the themes that I've developed at more length through the discussion today. Harnessing the power of private investment, not creating disincentives to such investment, eliminating regulatory barriers, eliminating, to the extent the state can, problems related to access to public and private rights of way, favorable tax policy, smart targeted expenditures of public funds to alleviate market failures in cases where they exist, These are the measures that I think the state should take and to some extent is taking to encourage broadband deployment.
I would agree with all of those, and just to pick up on a theme that Michael was talking about, the commission has always had a real sweet spot in terms of being an honest and expert broker, whether it's with municipalities, whether it's with other state public entities, whether it's with companies. So I would encourage the commission to continue to be involved in those issues. And I think everything else got covered.
Picking up on a couple of those points, could you opine on the issue of if we're being an honest broker and some people are looking at possible market failures and even though it might be outside of our area of jurisdiction, what does the panel think about a situation where a municipality believes that there's been a market failure because the prices and the services of the incumbent are inadequate, and it wants to create its own broadband municipal district and use public funds to do so?
I think that a couple of things. One, we have Common Cause supports municipal broadband and opposes a state-level policy to limit or curtail it. We filed as interveners in support of the FCC and its preemption decision. I'll also add that that municipal broadband is important for a couple of reasons. One, it is a source of competition, obviously, but also the threat of municipal deployment is often enough to, in terms of leverage, to encourage sort of another kind of preemption, which is incumbents investing more because they fear that competition may be on their doorstep to ward off municipal investment. Two, I don't see any particular problem with municipalities have public funds. They should be expending them to meet public needs. Universal broadband service, affordable, fast broadband service is a public need, and if the municipality decides that they are not being adequately served, irrespective of whether this is a market failure, quote unquote, if the city decides that this is what it needs to do to serve the needs of its citizens, I see no reason why anyone should stop them. Lastly, on the broader point of market failure, I think sometimes we have this false schema where the public sector is only supposed to act, only supposed to intervene in times of, quote, market failure. We're only supposed to regulate when there's a market failure. Well, I don't buy that because there are all sorts of critical public interest and consumer protections that we want, that we regulate, that we legislate because they're the right thing to do, irrespective of the competitive landscape. A great example, we have laws that prevent discrimination in the provisioning of hotel rooms, right? Because they're public callings. That goes back a long, long time. Why? We have a very competitive hotel market, but the simple fact that we have, it's not like this is an either or. We still want laws that prevent discrimination in the hotel industry because it's the right thing to do. And we often sort of proceed from this idea that we only have consumer protection or we only have public interest intervention at times of market failure. But broadly speaking, I know this goes beyond your question, I don't buy that.
Just on the specific question of municipal broadband, we've done a lot of work on that issue, and we have a pretty lengthy report out on it. We presented at NARUC on it before, and Commissioner Sayer has heard it, I believe. But on the specific issue of if a municipality decides that it wants to build its own system, I would urge any city that's looking at this issue to make informed decisions about it, because it is a very complicated thing to do, and it's also a very expensive thing to do. So to be able to either dedicate existing funds or to assume more debt to build a network, it's a pretty big step for a municipality to take, especially some of the smaller ones that have very tiny budgets and debt limits and things like that. So, the only thing I would argue would be for municipalities to take a couple of steps back and to really think about it and to see whether there's a real need, if they've already thought that there's a market failure, or have they gone through a litany of other things that they could do to attract a competitor potentially. If it's some of the things around the Google model, kind of tweaking some of their requirements to maybe attract a new competitor, things like that. And then also looking at the business case, because there's been a pretty long history of some cities that have built these networks and failed because of either very tepid demand for the system, even if it does offer comparable services at comparable prices to the incumbents. In a lot of instances, people just stay with the provider that they have. And also, there have been other instances where the incumbent has responded by cutting prices and kind of driving the municipal's network out of business because the municipalities generally aren't as nimble as a private provider. I've heard some people argue that that's actually a good thing, that all of that work was good to nudge the incumbent to lower its prices, but that's a pretty costly investment to get to that point. So, I mean, ultimately, my personal view on this is that a municipal network should be the absolute last resort, especially in areas where there's already service. There's a more compelling case in areas that aren't served, but in areas that are already served, I think it should be last.
I'll tell a quick story if I might. I grew up in Wilson, North Carolina, which is famous for its fiber municipal broadband network. And I've talked at length with the city about how they came to the decision to build a municipal broadband network. And it really is the pride of my hometown that they have the fastest broadband in the state. They're very excited. And there was a traditional tobacco and textiles economy, and somebody looked up and realized and said, the days of big tobacco are over, so what are we going to do? And they asked the local cable incumbent, in this case it was Time Warner Cable, would you be willing to upgrade? We've heard demand from our small businesses. We want faster service. And the mayor of the town called one of the local sort of, I don't know if it's regional vice presidents or whoever it was from Time Warner Cable in and said, this is our idea. We would like gigabit connectivity in Wilson, North Carolina. And Time Warner Cable, I'm not making this up, this is a matter of public record, literally laughed in their faces. So there's no, you don't need that. They literally laughed in their faces. The meeting was over in less than 10 minutes because they said, we're not interested in serving you. We don't care what you say. We don't care that you report that there's demand. We don't believe it. So then the city went to the other incumbent, which was at that time called Embark, but through mergers and acquisitions and name changes and all, it's not Embark anymore. And Embark was much more open to a public-private partnership. They didn't want to build a municipal fiber optic network. This really was a last choice. And they worked with Embark, and they had a memorandum of understanding that the city was going to lay fiber, that they were going to manage customer relationships through their existing municipal utility, and that they were going to run the service trucks. They were going to handle most of it. Embark was going to handle the telephone because, as we all know, telephony is complicated. Seemed like a pretty good balance of risk and reward and responsibilities. They had an MOU that went all the way up to the Southeastern Regional Vice President at Embark, and they had the local folks come out to the city council meeting and address the city and tell the mayor and the council members what an exciting new thing they were doing, and this is going to be a model throughout the Southeast. And it went all the way up to a regional vice president who said, we can't have that. Margins aren't good enough. We're going to shoot that down right now. This stops at my desk and goes no further. Because they were worried that it would be successful at margins that weren't acceptable, and that it would be duplicated in other communities. And again, there was money to be made there, but not enough. And so they said, no, the status quo is better for our margins. So they shot it down. And it was only then that the city said, fine. Seeing no other alternative, we will build our own network. And it has been, by all accounts, pretty successful. Their take rates are way ahead of their initial projections. They were they realized an operating profit years ahead of schedule. And I'll add, they serve every address in the city. That there is no redlining, because any household within the city limits that requests service, even if you're a farmhouse that lies within the incorporated limits, even if you're half a mile off of the road, and it is extremely capital intensive to wire that home, by charter, if you live in the city limits, you get service. And I'm a little proud because it's my hometown, but I think the idea that they sort of like rushed into this bullheaded and that they didn't do their due diligence belies the facts, right? And I think it also speaks to, everybody throws around the words public-private partnership like it's an easy thing to get done, but sometimes you find really willing partners on the public side and no one wants to work with them. So.
There are two levels of issues here. One is the legal issue, and I don't pretend to be an expert in municipal law, so I couldn't tell you whether municipalities in New York have authority to, under state law, to build broadband networks, but that's certainly an issue that would have to be investigated. As a policy matter, I think I lean more towards the nuanced approach. I'm glad this worked out for Wilson, North Carolina, but for every story with a happy ending, there's a horror story of a municipality that got in over its head and made unwise investments and compromised the provision of other perhaps more important municipal services. I don't think there's any bright line answer. There's a lot of things, just as a business has to evaluate a lot of things in deciding whether to make an investment. A municipality needs to evaluate a lot of things. It needs to look at feasibility, management, whether they can ensure the continuity of service, the financial aspects for the municipality. Sometimes it will work, sometimes it will not work. And I don't think you can say that this is either a good thing or a bad thing. Sometimes it will, if it's in the wrong environment, it could create an unsustainable municipal system while creating disincentives to private investment, which in the long run is not a good thing for the municipality. So it's something that, as I said, and I think as Mr. Santarelli said, requires a very nuanced approach.
And I would just also urge that you look at the electric experience, because there was a period of time, I'm going to say 10, 15 years ago, where there were a couple of consultants in particular that just went from town to town on the electricity side and said, you can build your own cogeneration plant, you'll save all this money compared to, XYZ utilities bills, gave them half the story. And, to answer your specific question, Commissioner, that may be a place where the commission can come in and at least ask the municipality or have access to staff so that they can ask the staff, what are the things we should be thinking about? What are the risks? What are the kind of issues that we may face down the line in terms of our own stranded costs and so forth? And at least have some balance if folks like that do start going out and essentially selling their wares to these municipalities.
So just to pull us back a little bit, because we've been talking about getting competition, and it seems to me that before we worry about getting competitive suppliers, that the first thing we should be worrying about is getting access to everyone, and so the concern is really how do you address the issues around things like Albany and Syracuse, where there are portions of the community that have access to broadband and portions that don't. And certainly our concern, despite Common Cause's comments in the merger, was the opportunity to actually build out the system where it wasn't being built out. And I think that I continue, and we don't need to debate it. But I think that for the people who aren't getting served today and will get served if the merger charter gets ultimately approved, I think they'll be a lot happier than thinking at some point in the future there might be a competitive supplier coming in. But I think that the goal of the state is to at least get a minimal amount of access and minimal amount of speed. And I appreciate everyone's thoughts on that regard. I would say that the Broadband Office and the Commission are very close collaborators, and We do work very closely together to take a look at how to expedite on that process. But the real question for me is in these communities where we have providers and there is a franchise, and yet we still have portions of the community that are being unserved, what could and should the commission be doing to address those issues? Because that is, the level playing field issue has become an issue, obviously, before us in terms of providers coming in and only wanting to serve a portion of the community. And then the other aspect is that where we have situations like Syracuse, like Albany, where you have basically people who seem to be wealthier getting services and people who are in less wealthy communities are not. And those are the things that I continue to come back to. How do we, as a commission, address it? Because it seems to me that's the heart and soul of what a Public Utilities Commission should be looking at. Any thoughts? Where 706, where FCC? Because ultimately, that's what the public looks to us to do.
Well, I think it starts with public hearings. I don't think the Public Utilities Commission can, or a Public Service Commission can hear enough from the public when it comes to making public interest decisions. And so, Susan, our executive director here, did a great job of organizing with our friends at CWA the public hearing on Fire Island a few years back. I'm pleased to see that the public sector is taking serious franchises and reviewing things like the FiOS franchise here. I think that separate and apart from the law is just simply hearing from people and hearing from small business owners and hearing from competitors that would like to know their market but can't, or hearing from school children, or you name it. Actually, 706 does specifically mention schools. So the listening tours and the public hearings you can never do enough of those, and I think that they can only redound to the benefit of the public interest.
Well, I think on the issue of enforcing franchises, I mean, they are contracts essentially between cities and providers. So if there is determined to be a breach of that contract, then there are remedies available. Certainly, and I think most franchises have remedies included within the contractual language. And so if it rises to that issue, then certainly those remedies should be invoked. I won't presume to talk for Verizon, but I think part of the issue around the FiOS discussion is around interpretations of contractual language. So it comes down to this being a contractual issue, but I'll talk about, in having the players who parties to those contracts either working together or collaboratively to solve issues in the contract, or if it becomes adversarial and you go to court. But I think I'll just talk about in the context of New York City, because I'm most familiar with what's happening here. And the fact that there are unserved parts of this city is still amazing to me, just given it's New York City. But it happens sometimes because, especially in New York, formerly commercial areas become residential areas, and they fall outside of franchise areas. So there's kind of gap areas. In the past, the city has, as the franchising entity, has worked with existing providers to figure out ways to build out to these areas, former warehouses that are now either startup hubs or residential buildings to accommodate population growth. And so in the past, the franchising authority here, DoIT, has worked with, I believe it was Time Warner Cable, in some of the areas to figure out ways to build out to these areas. In the past, the city has worked with Verizon on pilot programs for facilitating fiber build out. A couple of years ago, there was something around micro-trenching that came up. So in those instances, the city worked collaboratively with the franchisees to figure out solutions. But if they come to dispute over terms of the franchise, then there are other remedies available. In terms of the commission's role, I'm not exactly certain whether the commission has authority to intervene, I guess, in these issues.
Responding to the points about New York City, there are certain interpretation issues which on which the company differs with New York City. Those are being,
I don't really want to get into, I'm just generally, I'm looking at a policy question, or practical question, which has been dilemma since I've been here, is just, we have areas, and it isn't, because I understand there's a big debate, and we're obviously aware of it, between the Verizon and New York City, but in general, throughout the state, we have multiple cities that are only getting partial service, and that's, the question is what can we do from a we've talked about removing barriers, but, you know, is there something more sustainable that we can do rather than just, you know, looking at idiosyncratic build-outs? What can we do as a commission?
Franchises don't have to be renewed.
Well, we don't, and that gets back to the question, without a state franchise, can we accomplish something? And that's what I'm curious, because I understand, I don't want to get into a debate on who said, he said, she said, just generally, how do people make practical business decisions in these circumstances?
yeah. I don't think the issue here is cable television service. I think we're talking about broadband, and there's no franchising process currently for broadband. So the issue really isn't fixing or putting in place a franchising process. The issue is remedying gaps in availability that exist. And I'm not sure I have anything to add to what we've already been saying about that. If the gap is due to a market failure, a situation in which a private investment model simply won't work, I think the ultimate remedy, the model for the ultimate remedy is provided by the governor's broadband program. I think there's a lot that can be done through grants, subsidies, even measures, and someone mentioned this yesterday, perhaps it was Dr. Lerner, Dr. Crawford, about the possibility of financing guarantees, which may be a less expensive way for the state to reduce the costs of investment. All these things need to be looked at, without more detail about what the particular problem is in a particular place. I don't know that I can offer anything more helpful than that, than those general observations.
There is one thing, I think, in our regulations for cable TV franchises that has, and I'm not an expert on this, maybe Graham, you can help me on it.
I'll give it a shot.
A minimum standard in terms of build-out based on number of dwelling units per mile or...
Yeah, the minimum threshold Commissioner Sayre is referring to is a 35 homes per mile requirement.
So I'd like to ask the panel, given that cable TV build-out generally brings with it a broadband build-out, whether we regulate it or not, and given that technology has been changing in recent years in terms of how expensive it is to build new facilities, is it time that we took another look at that threshold and perhaps tightened it up?
Yeah, that hasn't really been an issue in Verizon's franchise areas. We have generally chosen to build out to the entire municipality. I don't think we have taken advantage of the primary service area versus non-primary service area construct. In the areas where we have proposed limited build-out, they haven't been based on that. So they've been based on other factors than the 35 per mile limit. So I guess this is a confession of ignorance. I have no idea whether in more rural parts of the state that has been an issue.
I think on the cable side, when the cable companies look at their ROI, it often is a different number than 35, based on the products and the demographics and so forth. So, obviously they have to comply with that, and if there is somebody who asks for service and they fall within that category, the company has to serve, but I think there are many cases where the company serves at lower than those numbers.
So if there aren't any other questions, we're going to take a quick break, and then we'll come back and wrap up. Sounds good?